We're in Detroit, Michigan for a pretrial conference. 51-year-old Carnell McCreary has been charged with assault and battery. 21 years earlier, McCreary was arrested, pled not guilty, and released on bond. But the case has lingered in the court system for years. Today, McCreary appears before Judge Elenice Bryant to discuss next steps.
Today is the date set for pretrial conference. Mr. McCreary, I understand that you are representing yourself, so how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions with all due respect.
I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McCreary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
While Judge Bryant attempts to proceed with the hearing, McCreary seems to have other things on his mind.
Well, if I may speak without being restrained again by the court.
You're going to be restrained every time you go off course. So you're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCreary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once this motion
is denied, anything further?
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCreary.
Yes, sir. Violating code of judicial conduct, judge. And I have been
doing this for 16 years. I know what I'm supposed to do.
After setting up the defendant's request for her removal from the case, Judge Bryant looks to wrap up the hearing.
Anything further with respect to this matter?
Oh, can I speak or no?
Oh, well, what else is there, Mr. McCreary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
I don't take things personally. Ms. McCreary, let me say something to you. So since we're talking, let's talk. I'm not going to keep going on because you've asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal. And that concludes the matter. You don't have to tell me it's not personal. I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McCreary, is concluded. All right, then, sir, you're all set. You have a great day, and you stay safe.
While McCreary takes up his request with the chief judge, his case remains pending. If found guilty of assault and battery, McCreary could receive a maximum sentence of 93 days in jail. Next, we're in Detroit, Michigan for a civil hearing. Lisa Lang has filed a suit against her brother, Vincent Lang, for $972. The dispute is over a headstone that Lisa claims to have purchased for their mother's burial site. Today, the siblings appear without attorneys before Judge Herman Marable. As things get started, Vincent appears to be having some technical problems.
Is there some special effect on your camera?
No, sir. I don't know why it's doing that. Just the first time I ever did that.
All right. So, ma'am, so you're suing him for $972 because is that what you paid for the headstone that you did?
Yes, I paid $600 for the marker and $372 for the installation.
So, ma'am, you're asking for an adjournment?
I would. My brother and I have a court date on July 26th for my mother's estate. My brother did some illegal things, and
No,
we need to get this sorted out. Yes, you did.
Judge, I gave you a packet with a lot of documents in it. It'll explain everything. Whenever she thinks she's about to lose in probate court,
You don't tell the truth.
she runs to the 67th court and tries to
That's not the
do
truth.
voluminous things, voluminous unnecessary court cases.
That's
And then
not the truth.
We've been in Judge Gwynn, we've been in Judge Marcus' case.
Hang on, stop. Did you provide her a copy of what's in this packet?
No, he did not.
I didn't ask you, ma'am, I asked him.
Judge Marable seems to be getting frustrated.
Did you provide her with what's in the packet?
No, sir, I wasn't able to because we just came out of probate court last week. They're trying to unravel the money that she stole.
I didn't steal any money. I didn't steal any money.
She's trying to circumvent probate court.
I am not trying to circumvent probate court because
I don't understand.
my brother deeded a house to himself. He lied and said that my mother had passed away 5 months ago, but she had passed away a year and a half. So that was dismissed and he lost the case.
No, I did not lose the case.
Yes, you did.
I did not lose the case.
Yes,
Judge
you
Marable.
did.
Judge Marable.
Boy, you know what? I can hardly wait to deal with the two of you. That was sarcasm.
Oh, I didn't
I can
hear you.
hardly wait to deal with the two of you.
Oh.
I'm so excited at the prospect of warring siblings. It's just going to be great. Better than one of those court shows on TV. I can hardly wait. Now, you know I'm being sarcastic.
I know you are, sir, and I hate that we have to be here, but
So never mind that. Let's deal with the legality. All right.
yes, sir.
If there is a case pending in probate to resolve issues regarding the estate, then that's where this ought to be dealt with.
I agree.
I bought that house from the Land Bank Authority. Mr. Lang tried to steal it and give it.
No, I didn't.
He's been a tenant for 16 years.
Okay, all right.
He has not been a tenant. He paid you for that house.
No, quiet. I got the
How
case.
would you know?
I got it.
He paid you for that house.
How would you know? You guys need to mute them.
By now, the judge has had enough.
I told them to stop talking and they're talking. Mute them.
After reading through the file, Judge Marable makes his ruling.
We're going to adjourn this for 89 days. Okay?
Thank you, Judge Marable.
The parties were scheduled to meet again 89 days later, but because both the defendant and the plaintiff failed to appear, the case was dismissed. Next, we go to White Cloud, Michigan for a motion hearing. 44-year-old Buford Smith is 16 years behind on his child support payments. Today, he appears remotely before Judge Michael Page because he's filed a motion claiming that due to medical reasons, he's unable to work. Also on the call is the defendant's ex and mother of his child, Brandy DeVore Boulis.
Sir, what are you requesting today and why?
I went to the specialist Tuesday. I have blockage in my left upper thigh. Something seriously going on with my right leg. I have no pulse, barely any pulse at my ankles. I can barely walk right now, sir.
All right. You attached a note here from Ryan A. Street.
I subpoenaed him like you asked.
Joining the call is Dr. Ryan Straight, who has previously examined Smith.
Dr. Straight, you said due to his health conditions, he is unable to work for the next 180 days. Is that correct?
Correct.
All right. And what health conditions prevent him from working for 180 days?
We were diagnosed him recently with diabetes. He was also having quite a bit of neuropathic pain. Ever since I met him as a patient, he was having chronic issues with his abdominal pain and diarrhea. Felt that his conditions were severe enough to warrant a note for that.
All right. Has your opinion changed in any later examinations or conversations with Mr. Smith?
My opinion currently is that I feel that he likely could work in some capacity.
Smith seems surprised with the doctor's response.
Wow. Wow. Do you know I got that?
Sir, be quiet. Sir, be quiet for now.
Wow.
What restrictions do you think you would have if you were to work?
Probably you would have to be limited in terms of standing, walking, likely some limitation in lifting.
All right. And then you said he was discharged from your office or dismissed?
That's irrelevant to this case. I object. I object. That's irrelevant to this case.
All right.
I object. I object to that question.
I heard you.
Irrelevant.
Do you have any questions for Dr. Straight?
Yes, Dr. Straight. I have barely any pulse at my ankles. How do you expect me to walk? Like, seriously. I'm going in for surgeries. Like, I don't get this. Why would you tell this man I could go to work?
That's just my medical opinion at this moment.
Randy, I'm not lying to you.
No.
I'm in rough shape.
You still have to pay
from all
for
that
your
drinking and all those cigarettes.
It's not my fault.
No, it's not. I'm just telling you. I'm seriously, I'm sick.
Not my fault.
Smith continues to plead his case.
I have no pulse at my ankles. They're talking about taking my feet, maybe my legs. And you expect me to go to work with no legs? Come on, man.
Ma'am, was there anything else you wanted to address today?
No, I just think he still should pay his child support. He's got 16 years of it.
And Ms. Evans, is there ongoing support and arrears, or just arrears, or what?
He owes a total of $54,056.24.
$54,000 in arrears?
Yep.
Smith does not agree with that figure.
That amount of money is ridiculous. Doesn't make sense to me. I'm sick. I'm not faking it. I have all the medical documents to prove it.
All right, I'm gonna take some time to review all these documents. I'll issue a recommendation in order.
Judge Page schedules a hearing for a later date. Till then, the case is pending. Next, we head to Cadillac, Michigan for a bond violation hearing. 58-year-old Joseph Bowen has been charged with possession and delivery of a controlled substance, methamphetamine. After his bail hearing, Bowen was released on a personal recognizance bond and ordered to undergo regular drug testing. But when he missed multiple tests, Bowen was ordered back to court, where he tested positive for meth and was remanded into custody. Today, Bowen appears with his attorney, Jeffrey Harrison, before Judge Jason Elmore to hear if his bond will be revoked.
Mr. Harrison, what are we doing?
Your Honor, Mr. Bowen is prepared to accept responsibility.
Well, Mr. Bowen, you understand, and you hereby admit to testing positive for a controlled substance because you would use a controlled substance?
I do, with explanation, no.
Well, let's go ahead. Let's hear what your explanation is. Don't tell me you smoked a cigarette with something in it. That's the most popular one I hear, and I know to buy it.
I found a box in my closet.
Okay.
And I'm cleaning it out, and I found some. And
found some what?
Methamphetamine.
Okay.
And I wasn't using much, but I used, and
okay.
Handling that, I believe it went through my skin. I did not ingest it.
Okay. Don't even try that.
I'm not sure.
No, I'm not gonna buy it. Let's just stop it. I don't know who in jail, no, stop. I don't know who in the jail is spreading these concepts. You can go back and tell them it doesn't work. No, stop talking. Ms. Perry, let's go ahead and put on a witness.
Thank you, Your Honor. People call Miss business.
It went through my skin.
After hearing from a jail employee who confirmed the positive drug test, the judge makes his ruling on the bond violation.
The court hereby finds the defendant in violation of his bond. I don't think any argument is necessary. There's no evidence produced other than the test. Mr. Bowen, you came in here and tried to lie to me. There's no way I'm going to allow you back on bond. You tried to tell me it went through your skin. Don't even talk. This is not going to help you. No. I'm going to send a message back to that jail through you. Do not come in here and tell me it went through your skin by accidentally touching it.
I was not trying to lie to you. I was trying to tell you how it became to that use.
Okay, so it went through your skin?
No, I handled it, and once I handled it and I seen it, there was just a little bit there, I used it.
Well,
I never said
I appreciate
that it went through my skin, sir. I think that.
All right, well then
Your Honor,
maybe I misunderstood, but you were starting to go down that road, but I'm going to tell you what, the answer is today, the court's revoking your bond, remanding in the custody of the jail.
There's no way I can get a bond or.
Not right now.
I'm just.
The answer is today, hold on. The answer is today, your bond's revoked. You were continuing to use the substance that you're charged for possession with intent to deliver. Thank you. We are adjourned.
Bowen eventually pled guilty to possession, and the delivery charge was dismissed. He remains in custody as he waits to be sentenced. If convicted, he could be facing up to a year in jail, plus a $2,000 fine. Next, we're in Detroit, Michigan for a pretrial hearing. The defendant, 40-year-old Kevin Hurst, is being sued for unpaid credit card debt of $1,196.73. Today, Hurst appears without an attorney before Judge David Robinson. The plaintiff, Midland Credit, is represented by attorney Suzanne Strickarts.
Okay, where are we on this file, people?
We did send discovery out. We did receive it back, apparently unopened. On the envelope itself, it had written, "I do not accept your offer to contract, all rights reserved, UCC," and then it was a return to sender, Judge.
All right,
so
Mr.
we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me, sir.
Thank you, sir. Okay. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
No, I don't.
The plaintiff had sent Hurst a request of admissions, which asks the defendant to either confirm or deny specific statements. But right now, Hurst is concerned with other matters.
Your Honor, I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. When they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
I'm going to mute you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst,
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute
I don't even understand what's going on.
I'm muting Mr. Hurst.
A few minutes later, after being unmuted, Hurst continues to argue.
I told him I have no recollection of the debt. I don't even know enough information to admit or deny the allegations to the debt.
When Hurst is finished, the judge explains the importance of the written discovery.
If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making.
Judge Robinson decides to give Hurst a break and ask the plaintiff to mail the paperwork a second time.
And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand.
If you're not going to participate in discovery here, you're going to find things are going to go against you very quickly. Go off the record.
Thank you, Your Honor. Have a good day.
Be safe.
2 months later, after the paperwork was mailed a second time, the parties met again to discuss the case. There was just one problem.
So, the defendant has failed to appear. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff.
Thank you, Judge. Have a wonderful day.
And you too, Mr. Gartz.
The judge ruled in favor of Midland Credit, and Hurst was ordered to pay the $1,196.73. Next, we're in Wyandotte, Michigan for a bond violation hearing. 30-year-old Anthony Carmona has been charged with disorderly conduct. 3 months earlier, Carmona was arrested for being intoxicated in public. When he appeared at his arraignment before Judge Elizabeth DeSanto, his mood was decidedly friendly.
Yeah, can I say something?
Sure, sir.
And this is the only time I can say this, you're very pretty. And I'm just gonna leave it at that, and I'm done. I'm not saying it again.
Okay, thank you, sir.
Why did I say that? Okay, all right.
That's not going to affect your bond determination, I can tell you that.
I just need you to know that truth. That's all.
Okay.
They can't take me to jail for that one, because that's the truth, baby. I'm held under oath.
Carmona was released on $2,500 bond and ordered to wear an alcohol tether and regularly report for drug and alcohol testing. But when he missed a few tests and failed another one, both violations of his bond, he was ordered to reappear before Judge DeSanto to enter a plea. Carmona appears remotely, and he's represented by attorney Christopher Schemke. And today, there's no flirting or playful chit-chat.
As to the allegation that you tested positive for marijuana, as well as failed to appear for testing in violation of this court's bond conditions, how do you plead?
Guilty.
Will accept your plea. Counsel, why should I not revoke your client's bond and have him remanded to jail until his next court date?
He had used marijuana, but is not currently using marijuana. As to the missed court dates, unfortunately, Mr. Carmona did suffer an extreme loss. He was seeing someone, he was in a romantic relationship, and that person had an overdose and passed away. It was a challenging period of time. It still is.
And sir, why didn't you appear for the testing?
I was actually trying to go to the hospital the next day. My main focus was seeing her. That day, I can say I wasn't thinking clearly.
Here's what the court's going to do. The court's going to indicate 10 days jail for your bond violation.
In Wayne County?
Yes, sir.
Ma'am,
Wayne County.
Please, no, please. I can't. I literally, please, no, please. I will do anything. No.
No.
What you're going to do is you're going to be reporting to Wayne County Jail tonight at 6 o'clock.
No, please. Judge DeSantis, please. I'll do anything. They're gonna kill me in there. If I'm being honest with you, it gives me suicidal thoughts.
Given his state of mind, Judge DeSanto decides to keep Carmona on the call while police try and determine his location.
Sir, you're indicating that you need some mental health treatment. So where is it that you're at?
I'm not gonna tell you where I am.
Why not?
Because you guys are gonna come get me and throw me in jail. I just told you I can't go.
I'm making sure that you are safe and that you're not harming yourself.
For the next 3 hours, Judge DeSanto keeps Carmona occupied, while her other cases are forced to wait.
You act like I'm some crazy criminal. I got drunk one night. Have you never gotten drunk? You know what's really funny is that Wyandotte held the Guinness Book of World Records for a while for the most bars and churches per capita. There will be a suicide on your hands if you cannot help me here.
Sir, I'm trying to help you.
Eventually, police figure out Carmona's at a nearby hotel and appear outside his door.
No way.
Really? Oh my God.
What's that?
I knew this was gonna happen, man. You guys are really locking me up.
I said you're okay.
I'm fine.
You said some questionable stuff I was doing.
Guys, please. No, I'm good.
Do you still need us on here, ma'am?
No, that's okay.
Police take Carmona into custody and bring him to a mental health facility for evaluation. 7 days later, he appeared again before Judge DeSanto to hear his sentence.
How are you doing?
Well, better.
Good. Good. So you spent a few days in treatment, correct?
Yes, ma'am.
All right. And then you were given some medications?
Yes.
And are you taking those medications?
Appropriately.
Okay. I'm encouraged to see that you seem to be taking your mental health seriously at this point.
Yes.
The judge sentenced Carmona to 12 months probation, which included mental health counseling and continued drug and alcohol testing. As for the 10 days in jail for violating his bond, he received credit for the 7 days he spent in treatment.
Thank you.
The remaining 3 days have been suspended by the court, pending Carmona's successful completion of probation. Next, we're in Adrian, Michigan for a pretrial hearing. 39-year-old Stephanie Rice has been charged with 3 counts of aggravated stalking in 2 separate incidents. Over the course of a year, Rice was accused of stalking her ex-husband and his girlfriend. Rice, who has 2 children with another man, was released on $10,000 bond with the conditions she appear at follow-up hearings, be regularly drug tested, and that she check in with court services on a daily basis. After Rice failed to appear at multiple hearings, she was held in contempt and a warrant was issued for her arrest. She was later released on a new $75,000 bond. Today, after further violating her bond by testing positive for methamphetamine, Rice appears before Judge Anna Marie Anzalone.
Ms. Rice is charged with aggravated stalking, which carries a maximum penalty of up to 5 years in prison and/or a $10,000 fine.
The judge hears first from State Prosecutor Phoebe Meir.
In preparation for the trial, I did meet with the victims in this case, and they are quite frankly just fed up with this at this point. So I will dismiss these felony charges as well as the PPO violations and ask the court to sentence Ms. Rice to the maximum on the contempt of court.
Judge Anzalone then checks in with defense attorney Salvatore Malaro.
Mr. Malaro, are you going to object to dismissing the underlying file as well as PPO violations?
Judge, no objection to any of that.
Very good. I will move to the issue of sentencing on the contempt of court.
I'd ask the court to use its wisdom and fashion the most lenient sentence as many jail time as it possibly can.
Ms. Rice, is there anything you'd like to say on your own behalf?
Yeah.
Okay, I need you to go stand at the podium for me.
An emotional Rice addresses the court.
I know that my kids will be in foster care if I go to jail. I don't have anybody to watch them. Their dad has not seen them in over 2 months. And I'm not using.
The judge looks for confirmation from a member of court services.
Mr. Coast, you administered a test today to her, is that correct?
Yes, ma'am.
And did she test positive for anything?
Tested positive for the THC, amphetamines, and also methamphetamines.
All right, so Ms. Rice, we've got multiple tests showing your levels are dangerously high. So I have great concerns about your mental health, your physical health, and your just defiance from day one of the court's orders, and also a downhill spiral that I'm seeing in your behavior. You know, I think you got off very lucky today because the charges are being dismissed, but I am going to sentence you to court or to jail for 93 days.
Please don't do my kids with me foster care. Please don't. Please,
Get
Judge.
credit for any time you've already served.
Can you please
Drop
just
that.
give me a try? Please,
No.
Judge. Please, I'm begging you. I'm begging you. My kids are going to be in foster care. I'm begging you. I'm begging you.
Judge Anzalone leaves the hearing as deputies attempt to take Rice into custody.
Don't touch me. Don't touch me.
Rice was taken to the county jail and served her 93 days. Her 2 children were placed in the foster care system. Rice's 2 aggravated stalking cases were later dismissed, and she's currently working to regain custody of her children. Next, we go to Centerville, Michigan for a civil hearing. The city of Sturgis has filed 6 zoning violations against 47-year-old Michael Kling, claiming his property is uninhabitable. Representing the city is Timothy Reed, who's joined by Sturgis building administrator Will Pritchard. The judge on the case is Jeffrey Middleton.
No sign of Mr. Kling.
The defendant, who's already 5 minutes late, joins the hearing.
Good afternoon, sir. Are you Michael Kling?
I am.
All right, would you please have a seat?
Absolutely.
All right, you're late for your hearing. Let's pretend like we're having a court hearing where people are respectful. Will you please take your hat off?
Yep.
All right. You got cited on 6 separate occasions for multiple violations of the Sturgis zoning enforcement ordinance. It looks dangerous in about 19 different ways. Mr. Pritchard, what's the status of that?
I went by there last week to condemn the house, and he had told me at that time he was working with an electrician to get the electrical fixed, and he was supposed to have it done by last Monday, which he did not.
Well, I'm waiting on state inspector.
As the judge continues the hearing, it looks like Kling lit up a cigarette.
He had almost 90 days to even respond. He never did. Mr. Kling is in default on all of these actions. What we're simply asking the court for today is an order of compliance, that he bring these into compliance within 30 days. The city is
over here. A lot is done.
Mr. Kling, another thing we don't do during court is smoke.
I know.
Please
I apologize.
put your cigarette out.
Yeah.
Judge Middleton then reviews photo evidence of the property.
There appear in the photographs to be electrical violations, plumbing violations, mechanical violations. It looks like a fire waiting to start. Sanitary violations. I think one of the pictures shows a generator on the inside of the house. The outside, the ground is scorched of any vegetation. There are junk vehicles all over the place. So this property didn't get this way overnight. To expect him to accomplish this in 30 days maybe a bit unrealistic.
Your Honor,
All right.
a lot of that
Mr. Clay?
stuff's been taken care of.
The city had been in contact with Mr. Kling almost a year prior, warning of this type of action coming forward.
I have all this time, and you just keep going.
Despite being granted more time to repair the property, Kling does not seem happy with how things are going.
Can I say anything, or is this just going to be a railroad
Yeah,
me? I don't think
we
I
haven't done
can.
anything yet, but yeah.
Well, I know we haven't.
Okay, go ahead. What do you want to tell me?
All the cars have been removed. Let me see. The building they wanted taken out is out. Most of the yard's cleaned up. My plumbing's finished. All the other is done. I got railroaded by a bunch of little here in town that up my property and my house. I'm not thrilled. I am not thrilled.
Well,
Sit here listening to this.
That makes two of us. Mr. Kling.
I bet it does.
If you curse one more time, I'm going to find you in contempt and order you be incarcerated. So we're in a court hearing. Don't drop the F-bomb. Don't swear. If you were here, I would have already had you taken out the back door by the bailiff. You wear a hat, smoking a cigarette, you show up late, and you're cursing in my courtroom. So let's try to have a little more decorum here, especially since you're the defendant and you're asking for some consideration from me.
The defendant complies, and Judge Middleton makes his ruling.
All right, I'm going to give you a little more than 30 days. We're going to continue this to April 27th. See what he can accomplish by the end of April, and if we get the property in compliance, everybody wins. All right, very good. I'll see you at 2 o'clock on
2 o'clock on the 27th. Okay, thank you.
Fantastic. Thank you.
Kling's case was continued for 7 months, but because he failed to make the necessary repairs, he was asked to leave the premises. When he didn't leave, the city filed an eviction notice. Kling eventually vacated the house, and the case is now closed. Next, we're in Traverse City, Michigan for a bond violation hearing. 40-year-old Curtis White has been charged with unlawful driving away, 3 counts of obstructing an officer, and being a habitual offender. 2.5 months earlier, police say they spotted White driving a stolen car, and when they questioned him, they say he became confrontational and was arrested. White was released on $25,000 bond, with the condition he be regularly tested for drugs and alcohol. Today, White's in the local jail because he missed 4 days of testing, and a bench warrant was issued for his arrest. He appears before Judge Charles Hamlin to enter a plea on his bond violation. His attorney is Jacob Graff.
Mr. Graff, let me start with you. Have you had a chance to review the allegations contained in the bench warrant with the defendant, and how would you be proceeding this afternoon?
We have, Your Honor. He'd be accepting responsibility to violating his bond.
So, Mr. White, sounds like you want to admit to missing the tests. Is that correct?
Correct.
You did miss those tests, even though you did know that you were required to take them as part of your bond. Is that correct? Okay. The court doesn't feel comfortable at this point taking a plea from Mr. White. I'm not sure where the lack of understanding between either he or I is taking place. So I think what we're going to do is I'll enter a not guilty plea on his behalf, and we'll get it set for a hearing.
The judge moves on to whether White should receive a new bond, beginning with a statement from the defense.
Mr. White was released on a bond. We seem to be doing well. It sounds as though there were some hiccups and maybe, he fell off the wagon and didn't follow through as he should have. I know the court may not be inclined to reinstate the prior bond, but Mr. White would like me to ask to see if the court would give him another opportunity.
Mr. Atwood, any comment for the people?
That's State Prosecutor Kyle Atwood.
Yes, Your Honor. I would ask that he be remanded pending the hearing. The allegations have to do, in large part, with substance abuse, and I'm not so sure that he's not under the influence of something right now. This involved the theft of an automobile, and he fought with law enforcement. So he's a public safety risk. If he's not testing, I'm going to assume he's using. If he's using, he's a danger to everyone else around him. So I think he's where he needs to be. Thank you, Judge.
After hearing from both sides, Judge Hamlin's ready to make his decision.
Well, I think given the issues that the defendant has had on bond in the past, he's already gotten the second chance.
As the judge goes on, White expresses his feelings to the court, not once, but twice. And the judge takes notice.
For the record, Mr. White was just flipping off the camera. He used both his left and right hand to do that. I probably would have been inclined to let it go had it only been a quick reference with one hand, but he did it with both, and he made an aggressive gesture toward the camera while doing it. Mr. White, I'm going to hold you in contempt of court, sir, and I'm going to sentence you to 60 days on that. There won't be any additional fines and costs associated with it. Mr. Graff, we'll see you both back for the hearing that'll occur shortly.
Thank you, Honor.
White was sentenced to 60 days for contempt. He was never charged with car theft, but the case for his unlawful driving away and obstructing an officer is pending. Next, we're in Detroit, Michigan for a plea hearing. 29-year-old Marissa Motley has been charged with appearing semi-nude at a sexually oriented business. 4 years earlier, police say Motley revealed a little too much of herself while working as a waitress at a strip club and was arrested. Since then, she's been free on $500 bond.
Marissa Motley.
Today, she appears remotely before Judge Michael Wagner to discuss next steps in her case.
You're charged with one count of appearing semi-nude in a sexually oriented business. The people have indicated that if you were to plead today, they would give you what's known as a 12-month delayed sentence. That means 12 months from today's date, you're going to get a fine of $225. If that fine is paid and you have not picked up any other cases, this matter would be dismissed and it would not be on your record. Do you know how you want to proceed today, ma'am? Or do you want to set this for trial?
I'm going to move forward and just plead guilty.
All right. Did you talk to an attorney, ma'am? Ma'am, you have to zip your sweatshirt up.
Yes, the defendant, accused of the crime of appearing semi-nude, is being told to zip up.
I'm sorry.
After adjusting her top, Motley explains her reason for pleading guilty.
It's the only way I would be able to move forward because I'm trying to get accepted into nursing school. I already took the other necessary requirements to get in nursing school, but I feel like 12 months is kind of steep when I didn't do anything wrong. I was at work, like I'm working. So,
ma'am, I can't get into that. If you want to have a trial
I'm just going to accept.
If you're telling me you don't feel like you did anything wrong, you cannot plead guilty because I can only accept a guilty plea from somebody who is guilty. If you have
because it would be a delay. It would be a delay.
I understand that, ma'am, but ma'am, if you're not guilty, we have to set you for a trial. Now,
I'm pleading guilty.
No, you already told me you weren't guilty, ma'am. I can't just.
I mean, they said my butt cheeks. They said my butt cheeks were out. And I didn't know that we couldn't be dressed like that. And they said, your butt cheeks are out.
Ma'am, I can't hear what the facts are before a trial date. So that's why we have attorneys out there for you to talk to.
Motley seems frustrated with the judge, but determined to avoid a trial.
Well,
I'm pleading guilty.
Yeah, ma'am, we went through that. You told me you weren't guilty, though. Now,
I'm pleading guilty.
Hold on.
I'm pleading guilty.
I can't give you a trial date. Do you want a jury trial or you want a bench trial?
I'm pleading guilty. All I said was I feel 12 months is steep. I don't even remember. I feel 12 months is steep. That's all I said.
All right, ma'am.
Finally, Judge Wagner decides to accept the defendant's plea.
The court finds you guilty of this charge, ma'am, and your fine will be $225. You will have a 12-month delayed sentence.
Okay.
Then you're all set to go, ma'am. You can sign off. Good luck to you.
Motley has 12 months to pay her fine. If she fails to do so, the fine will increase and she could potentially be sentenced to jail time.